And I want you every day to use your time effectively and change your life. But right now, I'm worried about everyone outside that door. All right, we're next taking up the case of people of the state of Michigan versus Dakota Pine, file 24-3547FH. Appearances, please.
Thank you very much, Your Honor. May it please court, Robert Champion, appearing on behalf of Dakota Pine, who's seated at my left, Your Honor.
Thank you. Court also recognizes Ms. Laura Odell, an agent from the Department of Corrections. We're here today for sentencing. We are doing a sentencing with a plea and elude third based upon a plea taken on November 4th. Objections to the PSI, Mr. Ringster?
Yes, Your Honor, we have no objections. So we do believe we start off with PRB 2 should be at 30 points. For 3 felonies. Let's have 2 of the yes, 4 or 7 is unlawful use of a motor vehicle, which should be 1. 5 and 7 would be unlawful use of a motor vehicle, which should be 2. And then what was another one? CSC third, it was dropped down to assault with intent to commit CSC second, which is 2 or 7.
I'm sorry, assault with intent to commit CSC second?
Yes, Your Honor.
All right, and, oh, we're talking felonies. I'm sorry, keep going.
So it would be 3 felonies as total. Mr. Blazak, when he was doing this, he counted one of the motor vehicles unlawful use as a misdemeanor instead of a felony.
It was, so unlawful use can be a felony or a misdemeanor if it's a first. So that's the key question here, it sounds like. So let's take a look. Which entry in CFJ 284 is it?
According to him, which one he had scored was actually the first one was.
Oh.
So we have 4 or 7 and then 2 of us.
All right, so I see an unlawful use for number 4. And he had an unlawful use charge number 3, but wasn't found guilty. And then we turn to number 5 of 7, and that is a second unlawful use. And it says misdemeanor in the parenthetical. You know, for me to be able to grant your request, I need to know what happened. Now, the one thing that gives me some reason to think that number 4 of 7 is a felony is the period of probation. It would be 30 months. And isn't there a limitation on probation for misdemeanors, Ms. Odell?
Yes, Your Honor, I'm looking at the PAT code for that, for
Yeah.
the offense listed in number 4 of 7.
Yes, ma'am.
The PAT code is 750414. It's a 2-year high court misdemeanor, which is scored as a low severity felony.
Yeah, that would make sense. All right, Mr. Champion, do you have anything to add to that? All right, so we'll go ahead and allow that correction for PRV number 2, and that goes from 20 points to what, Mr. Ringstrom?
It would wind up, I mean, originally to have it be 37 points instead of 27 points.
No, the PRV total number, so that goes up to for the PRV number 2, not the total.
Oh,
number,
PRV number 2 would be 30 points.
30 points. Now, does that change the scoring for the misdemeanors?
I do not believe that in and of itself would, because people do acknowledge that by scoring PRV 2 for 30 points, PRV 5 should go down to the 2 points for the 1 misdemeanor.
That's what I meant. So again, so PRV 2 is now 30, PRV 4 is still 2, PRV 5 is 2, so we're at 39 points. All right?
34 points.
34 points. Thank you very much. Why anybody would trust me doing math is beyond me. Thank you. All right, so does that impact the guideline range? Let's take a look here. We're at a class E felony. First one there wins. We are now at 34 points. That looks like it is Now a class, D grid, which means, we don't have any change.
No
Not
change.
yet.
Bam, all right.
And then we do have OB 19, we believe should be at 10 points. He was fleeing and eluding the officers, thereby making it so he was trying to escape justice.
Is this the one where there was some high rate of speed?
Yes, Your Honor.
Yeah. Mr. Champion,
I'll leave it to discretion.
the court will add the 10 points for OB 19. That's going to make the total OBs go from 1 to 11. And that will have an impact to make it go from a 5 to 23 to a 7 to 23.
That is correct, Your Honor.
Any other amendments or corrections, Mr. Ringster?
No, Your Honor.
Now over to the defense.
Your Honor, minor ones on CFJ 145, sentence date would be today's date.
Oh, yes, thank you. Yep, I have that circled. Thank you.
And also the jail's credit would be an additional
11,
11 days.
or actually 10, because you don't count today, because you'll get credit for today once it gets back. So that is an additional 10. So now we're at 109 days of credit. That's going to be changed on 145, page 2, as well as page 1.
With that, I have no other additional sections.
Allocution, sir.
Your Honor, the code of the situation recognizes that what he did was wrong. He understands that. His main concern throughout while incarcerated is getting treatment. He has arranged a treatment on his own that is awaiting for him. Here's a young man who has had a substance use disorder since he was 12 years old. Very bad situation that he grew up in. He understands he needs to be punished. I would ask the court not to consider a commitment DOC. What I would ask the court to structure a sentence that will allow him to be on probation after serving a jail term, along with the inpatient treatment that he has already set up on his own and will be accepted as soon as the court sets a date that he can be released to that program. So with that, Your Honor, given his age and being 22 years old, dealing with being, since he's been in that situation, and also my client just pointed out to me that his peer recovery coach is actually here in the courtroom.
I wondered why Miss Potts was here. I recognize that's what she does at the jail, and I appreciate that. And I make a lot of effort to try to help keep that program funded and going through Catholic Human Services. So I see her shaking her head in the background. And for the record, she's been here pretty much all morning. Why she has stayed and listened to me talk all that much, now I understand why. Thank you. Anything else?
Nothing else, Your Honor.
Thank you. Over to the people.
Your Honor, defendant's actions and history would warrant a prison sentence. However, I do want to put on the record, and I understand that is recommendation from Department of Corrections also. People are not going to oppose, if the court wants to, the idea of a year incarceration with immediate rehab afterwards, but that is up to the court.
All right, thank you. Now, Mr. Pine, we're at you. Is there anything you wish to say today, sir? All right.
Struggle with addiction. So to find myself, I've changed my life. It helps since I've been in jail because I know what I did was wrong. I was under the influence of methamphetamine when I committed this charge, using that as an excuse. That I had a problem. I called the rehab. They accepted me. They told me to call back Friday after I get sentenced and schedule a bed for me while maintaining Mrs. Platt's class as much as I can. I'd like to change my life and move forward from this.
Thank you. Just need to look at something here. Okay. Well, I'll tell you, there is, I make these notes and I tell people, because this is what I sometimes write. Wow times 5. That's what I said. Wow times 5 again. Because that side had a slam dunk if these facts were all true and came out at a trial. You were reaching speeds of 95 miles an hour. I'm sorry, the defendant continued to accelerate with the deputy reaching 95 miles an hour. And you will continue to pull away. And then you continue to accelerate. And this took place on Boone Road and Sealy Road, which are, as we all know, highly traveled roads between Wexford and Missaukee County. And you endangered the lives of a lot of people. Another one says here you're driving over 100 miles an hour at the intersection of East Boone and Platte Road. And you continue downtown towards Cadillac. Is there a case pending in Wexford? They had to set up sticks near Mitchell Street and North Street, which is right downtown in Cadillac. That's what it took to catch you. You eventually turned into the Save-A-Lot parking lot right downtown in Cadillac. It took officers to draw firearms to get you to stop. You had possession. You had a clear bag of methamphetamine found in your vehicle. You had a knife with brass knuckles. It's worth 5 years. The methamphetamine up to 10. The multiple jurisdictions could be added. And the fact that you were high on methamphetamine at the time you operated, not only as a possession, not only as a use, but as also an operator while underneath the influence, while you put everybody at risk and in danger. In addition to that, you have some significant criminal history as both a juvenile and an adult. Your affinity for knives apparently shows back when you were a juvenile, because you had a probation violation, it looks like, because you brought one to school. Then, of course, we know what one of the prior juvenile adjudications was, and it was quite a serious offense. I won't discuss that here, but we all know what it is. And it appears in CSA 284, page 4. Then when I get to page 5, I see a similar nature's offense involving dangerousness to a person, although it's a CSE, but it's assault with intent to commit. Then we've got receiving, concealing property. We have got unlawful driving away, unlawful use of motor vehicles. You've been to jail for up to a year. Taking vehicles seems to be an issue. Then you get a retail fraud in 2001. And you pick up these charges. Again, wow, times 5. There's a killer brew agreement that the people won't bring any charges for another flea and elude. Was that on a different day?
It was on a different day with back.
Oh. Yeah, wow. I'm gonna make that wow times 10. This is an amazing deal that you've got. I'm not saying that to criticize the prosecutor. Don't take it that way. I'm highlighting that to be a benefit that you have received. Plus, was there a habitual offender 4th? You were facing life, and most likely all of this was caught on camera. I appreciate that you've been getting some treatment, and that's great. That's what you need to do for you. But I'm not, right now, I'm sitting here looking at this and I'm seeing a 22-year-old person. I don't want you to take away that I'm saying I'm throwing it away and giving up hope on you. Absolutely not. But I also recognize that with youth comes a lot of living. I've got to think real hard to remember where I was when I was 22. It's not real hard. I know I was in law school, but I don't remember what year, and I can't remember which apartment we were living in Chicago. I know we couldn't afford to eat, but anyways, that's different. 22, you got a lot of living to put this behind you. But you've had a lot of breaks, and that side of the courtroom gave you huge breaks. I understand, but this is this is always interesting to me because it's now when I get to apply my discretion. They have all applied their discretion lawfully, and I don't take any criticism against it at all. But yeah. This court sentences the defendant to $68 state minimum fee, $130 crime victims' right fund fee, a $300 court cost. I'm just going to do, I'm not going to do any fine, but I'll do a $300 attorney fee. Was there DNA already available, or do I need to assess a fee?
I don't have.
I assume it was available. It should be available. There won't be any DNA fee. There won't be any supervision fee. This is probably the one time a day I wholeheartedly support the recommendation. In fact, I'm pausing because I don't know if it's enough. But I'm going to go along with it, stay within the guidelines. All the factors I've discussed already address the proportionality and reasonableness. The court sentences the defendant to a prison term of 23 to 60 months, and the court issues 109 days of credit. Mr. Fine, you put everybody in your path in danger. It 2 counties, high-speed chases. You've seen too many movies or something. And these graces are probably coming to an end. Have I missed anything, Mr. Blazak? Mr. Ringstrom?
No, you're not.
Mr. Fine, Mr. Champion's bringing you 2 copies of one document. This document tells you that you have the right to appeal the conviction sentence in your case. You're going to place your initials on the first page. Doing so neither elects nor waives any rights. It merely acknowledges receipt of the other copy of the document. This document, again, you have the right to appeal. However, because the plea was by because the conviction was by a plea, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Mr. Pine, I want you to find hope. I want you to see hope. And I want you every day to use your time effectively and change your life. But right now, I'm worried about everyone outside that door. Good luck. We're adjourned.